Hello, and thank you for taking the time to look at my video on my YouTube page. My name is Jamal Jones, and I am a health law attorney residing and working in the state of Florida, Miami, Florida to be exact. Today I'd like to talk about free transportation for your patients. Some cases, patients are unable to pay for transportation to and from their uh, healthcare provider. So providers uh, decide to pay for the transportation for their patients. Now, there are some considerations that you should take into account before you decide to do so. And this video kind of discusses that. Not at length, but it kind of gives you an overview of some of the things that you have to look out for when providing free transportation to your patients. If your physician practice provides free transportation for your patients, again, most healthcare providers, whether you're a chiropractor or a primary care physician, this applies to you. You should be careful. Providing free transportation to patients or their family members is fraught with regulatory peril. On March 6, 2009, the Department of Health and Human Services, Office of the Inspector General, or OIG, as we refer to it, issued an advisory opinion providing some further clarification on the provision of complimentary local transportation by healthcare facilities and providers. In general, providing free transportation services to patients could create problems since it implicates both the civil monetary penalty law and the anti-kickback statute. Legislative history shows that Congress did not intend to impose penalties for free local transportation of nominal value, which the OIG has interpreted to be no more than $10 per trip or $50 per patient in the aggregate annually. The recent advisory opinion issued by the OIG analyzed complimentary local transportation provided by a skilled nursing facility for friends and families of its residents, and concluding that the free transportation would not constitute grounds for the imposition of civil monetary penalties under the CMP law, which is civil monetary penalty law, or administrative sanctions under the anti-kickback statute. The OIG enumerated the following reasons. Number one, the transportation would not be for residents to obtain federally payable items or services from the facility or for the benefit of the facility's referral sources. Two, the free services are provided to friends and families of all residents or patients, not selectively to the targeted population of federal healthcare program beneficiaries. The type of transportation, let's say it's a van owned by a nursing home and driven by its employees, must be reasonable. The service will only be offered locally. Now, it's up for debate what locally encompasses. We're not really clear as to what that may be, but I would say locally is within the county that your practice is in. The services will only be applied locally and marketing will be reasonably limited. Also, the availability of local public transportation is limited and a toll bridge separates the facility from part of its primary service area. Again, some of this was specific to that particular case. If you don't have a toll bridge in your town, then obviously that's not applicable to you. And if public transportation is scarce, then of course that applies to you. But if public transportation is somewhat abundant, then maybe you may want to exercise caution before paying for your patient's transportation. Also, the transportation is consistent with the facility's mission to provide residents with quality care through increased companionship. The cost of the services will not be claimed on any cost report or claim or otherwise shifted to any federal healthcare program. The OIG cautioned that although free transportation may have important and beneficial effects on patient care, it may also be a part of a fraudulent or abusive schemes that lead to inappropriate steering of patients, overutilization, and the provision of medically unnecessary services. Therefore, arrangements involving free transportation must be evaluated on a case-by-case basis and may require the review of additional factors. Although the OIG had previously issued guidance on the provision of free local transportation by hospitals and transportation that does not exceed nominal value, the OIG's most recent advisory opinion provides much anticipated guidance to non-hospital-based providers. Ambulatory surgery centers and physician practices and may consider whether structuring their transportation programs within the parameters of this advisory opinion would be sufficient to satisfy both the CMP law and the anti-kickback statute. However, prior to implementing a free transportation program, facilities are urged to consult their own healthcare attorney concerning their situation and any specific legal questions that they may have to evaluate the benefits and risks of such a program. So if you have any questions relating to the free transportation for your patients, or any other questions pertaining to your practice, please contact me. Again, my name is Jamal Jones, and I am an attorney at Jones Health Law. My office number is 305-877-5054. My cell is 917-912-8108. That might be the easiest way to contact me, because I'm constantly running in and out of the office. Or you can send me an email. My email is jrj@joneshealthlaw.com. And please visit our website at www.joneshealthlaw.com. Thank you very much for looking at my video again, and enjoy your day.